order. Today is March 25, 2024. We do have a quorum present, and we're going to jump right into the agenda here. Senate File 3994, Senator Champion, Minnesota Voting Rights Act establishment. Senator Champion.
Good afternoon, Mr. Chair, and good afternoon to the committee. Thank you so very much for having me today. As you know, Mr. Chair, that we have a number of people who are joining us. Secretary of State Steve Simon is with us. He's going to be online, and there's going to be a time when I would ask the chair to recognize him so he can speak. We also have Michael Pernick, who's counsel for the Legal Defense Fund, who's also online, along with Justin Erickson and B.B. Black, who are also from the Attorney General's office, from the Secretary of State's office, who will also talk in detail along with me about an amendment that we're going to put forth, which is the A5 amendment. But before that, I'd like to, Mr. Chair, put this in context. I'm here today to present the Minnesota Voting Rights Act, a bill that codifies the protection of Section 2 of the Federal Voting Rights Act into Minnesota law, while strengthening, streamlining, and updating it to make it more efficient, effective, and less costly. The Voting Rights Act of 1965, which the DOJ calls the single most effective piece of civil rights legislation ever passed by Congress, ensures that the right to vote and to participate are not denied because of race. And unfortunately, Minnesotans no longer have the full protection of the Federal Voting Rights Act. In November of last year, as you know, the 8th Circuit, which covers Minnesota and 6 other states, upended decades of precedent by ruling that Minnesotans themselves can no longer challenge racially discriminatory laws and redistricting plans under the Federal Voting Rights Act. So what is before you is what we are calling the Minnesota Voting Rights Act. It comes in response to that federal court decision. And this bill will ensure that Minnesota voters once again have the right to challenge discrimination that they experience, because we believe that voting is a part of our democracy. Just for context, according to the census in the 2020 election, 80% of non-Hispanic white citizens voted, but only 66% of black citizens, 64% of Asian citizens, 62.7% of Latino citizens voted, and the average voter turnout rate in majority Native voting districts was only 49% that same year. So given these persistent disparities, Mr. Chair, it's critical that no Minnesota voter faces the effect of discriminatory laws or procedures, and Minnesotans deserve access to a private right of action and strong legal protections against voter suppression and vote dilution in our state. So the bill does 3 things, and then I would ask the chair to recognize the Secretary of State, but this bill does 3 things. Number 1, it codifies protections against laws that would have the effect of suppressing or diluting the vote. 2, it provides an opportunity to fix the discriminatory practice or procedure without going to court, and you'll see that, and we'll talk a little more about that. And it ensures that the law is applied consistently. So with that, Mr. Chair, and before we walk through the bill, I'd ask the chair to recognize Secretary of State Steve Simon.
Thank you, Senator Champion. Secretary of State Simon, welcome to the Senate Judiciary Committee.
Thank you, Mr. Chair and members. Steve Simon, Minnesota Secretary of State. Thank you for indulging this remote testimony. Normally, I'd love to be with you, but I just couldn't do that today. I'm proud to testify in support of this bill. We need it. The reason we need it, as Senator Champion said, stems from this alarming decision by the U.S. Court of Appeals for the 8th Circuit in which Minnesota sits. And here's the basic history. In 1965, obviously, the Voting Rights Act was passed. Section 2 of the Voting Rights Act created a remedy for, quote, denial or abridgment of the right to vote on account of race or color, end quote. So it basically gave people a day in court. Now, the common and unquestioned assumption since 1965 has been that both the government and private parties, individuals, Minnesotans, for example, could sue under Section 2. In fact, over the past several decades, hundreds of such lawsuits have made their way through the system, including at least 2 or 3 that went all the way to the Supreme Court, but no court ever challenged the underlying assumption that there was a private right of action until last November. In November 2023, a decision by the 8th Circuit changed all that, ruling for the first time ever since 1965 that there is no private right of action under Section 2, that only the government, the Office of Attorney General, the Justice Department, can bring such cases. And if the government doesn't want to bring a case, they don't have to bring a case. So our office is leading an effort among secretaries of state nationally to help reverse the Eighth Circuit decision. We believe it was wrongly decided, but in the meantime, the Eighth Circuit decision is the law of the land in Minnesota. So today, as we sit here, nobody in Minnesota has a right to sue under that part of the Voting Rights Act, under Section 2. So we need an insurance policy in Minnesota. If we can no longer count on the Federal Voting Rights Act to allow private citizens to protect their own voting rights, then we need a Minnesota Voting Rights Act to fill that gap. And that's what this bill does. It fills the gap by guaranteeing a day in court for Minnesota voters to defend their voting rights against laws or policies that they believe discriminate against them. And that's no guarantee of anything, Mr. Chair and members. It's just a day in court. Doesn't mean they're going to win. They might not. They're going to win sometimes, they're going to lose sometimes. But everyone under the Voting Rights Act should have a day in court and not depend on a friendly or sympathetic attorney general to do that work. This bill is necessary to ensure that every Minnesota voter can bring claims of voting discrimination to court. Inaction is not a safe option. I just want to say a word about what I know is to come. I know that Senator Champion will be introducing an author's amendment. I want to express my support in advance for that amendment, and I want to thank him for all the work that he and so many other advocates have put into this amendment. Staff from our office, the Office of Secretary of State, are here and will be able to provide a detailed review of the amendment, and they'll tell you what's in it. But I think it makes an already good and necessary bill even better. And again, I want to thank Senator Champion and all the advocates for a lot of discussions and getting to language that can work. Thank you, Mr. Chair and members, for your time and attention.
Thank you, Mr. Secretary. Appreciate your appearing here today, and no problem at all accommodating the remote appearance.
So,
Senator
Mr.
Champion.
Thank you, Mr. Chair. And so consistent with what the Secretary of State, Steve Simon, just talked about, we would like the body to adopt the A5 amendment, and then we hope that you adopt the A5 amendment, that you also will adopt the A7 amendment. And if someone moves the A5, then I will have Justin Erickson and BB Black to walk through the amendment, because again, that amendment was worked on with the cities and counties as well as the Secretary of State's office.
So Senator Champion, before we do that, I want to note for members that the intent is to move the bill to the Senate floor from here, just so you can anticipate what we're going to do. We can have staff pass out any amendments that need to be passed out this time as well, but they should already be in your packet. There's an A5 and an A7 that was already handed out. Members, there are a number of communications that are in your packets from interested stakeholders. I encourage you to take a look at those as well. There's also a fiscal note that is in your packets, and I believe one of the amendments is intended to bring that fiscal note down to zero. So it will not have a fiscal impact. With that, this is not the first stop, so we'll have to walk through the amendment and adopt it. I'm also told that the amendment does not make any substantive changes to other committee jurisdiction work. So we'll be in a good position to handle that here in this committee.
That is correct, Mr. Chair.
So which testifier would you like to have testify first, Senator Champion? BB Black or Justin Erickson?
Thank you, Mr. Chair, for the question. So if Justin Erickson, who's online virtually, could walk through the A5 amendment.
All right. So let's have Justin Erickson. There you are. If you go ahead and identify yourself for the record, and then tell us what you'd like to tell us about the A5 amendment.
Thank you, Mr. Chair, members of the committee. My name is Justin Erickson. I'm Deputy General Counsel for the Office of the Secretary of State. And to echo Secretary Simon, thank you for indulging me in this remote appearance. I'm going to walk through the bill at a relatively high level, hitting the major changes that have been made, but of course I'm happy to go into it in more detail if members of the committee would like. Lines 1.3 to 1.9 replace previous language in the bill that instituted a democracy canon of construction, requiring courts to construe language in the bill in a way that was favorable to voting, voting rights, etc. The new language does the same thing, but is consistent with the canon that Minnesota courts adopted approximately 100 years ago in a previous case, and so just brings it up to date with common law case law and that standard. Lines 1.10 to 1.25 replace the voter suppression standard with a new standard. The previous standard required a plaintiff to show that a challenge practice resulted in a disparity in voter participation among protected class members, or that under the totality of the circumstances, the challenge practice denied or inhibited protected class members' ability to participate or vote. The new standard that we've placed here for your consideration requires a prospective plaintiff to show that the challenge practice results in a disparity in voter participation among protected class members, and that the challenge practice is tied to social and historical conditions affecting those members. So as before, where it was either or, today you have to prove both of those elements. And now this new standard is modeled largely after federal Voting Rights Act case law that courts used for many, many years before a recent U.S. Supreme Court decision in 2021 that rolled back federal VRA protection substantially. We've proposed this standard for you because at the time of that U.S. Supreme Court decision, many states signed on to an amicus brief noting that this standard worked very well because it balanced both voters' constitutional rights while protecting government entities from unnecessary liabilities. And so we think this is a good standard that vindicates the rights that people are seeking to protect while also making sure that government entities are not subject to unnecessary litigation. I'll move down to line 1.30. And again, I know I'm skipping a few things here, but I'm happy to come back and address any of the other smaller changes in detail. Line 1.30 removes language requiring courts to consider political giving by protected class members in assessing whether a violation exists. This isn't a factor that's typically considered in federal VRA cases, and the office thought it would be difficult to assess whether such evidence is given, whether such giving is evidence of discriminatory practices. Moving to lines 2.6 to 2.11, this changes or adds information about what a pre-suit notice letter must contain in order to contain adequate notice before a person can file suit. So as members of the committee are aware, before you can file suit, subject to certain exceptions, you have to bring a pre-suit notice to the jurisdiction to let them know of the action you intend to file and give them a chance to remedy it. This new section provides information about what that notice must specifically contain. So as before, where it was more of a generic reference to a letter, this requires some very specific terms, some very specific information that must be considered in order for the notice to be considered adequate. Lines 2.12 to 2.16 remove provisions that previously authorized the Office of the Secretary of State to waive certain administrative deadlines regarding remedies designed to address violations of this act. And as I'll address later, some language has been added below to address those concerns. Lines 2.17 to 2.25 restate exceptions to the pre-suit notice rule when you no longer have to bring notice. It does remove a couple of exceptions from that rule. So before, you did not have to bring notice if the challenged rule or practice was enacted less than 1 year ago. That exception has now been removed. We also previously had an exception where you did not have to bring notice if the prospect of retaining relief would be futile. That exception has been removed in this draft as well. In addition, we've amended an exception which previously allowed a person to file suit if another party had submitted a notice letter alleging a substantially similar violation, and that person was already eligible to file an action. Under the new language, a person cannot initiate a new action, but they may join or intervene in a lawsuit raising the same issues without filing a notice letter. Line 2.26 lowers the cost sharing cap from $40,000 to $20,000 in cases where a matter is resolved following submission of a pre-suit notice and before there is a filing of a lawsuit. Lines 2.27 to 3.2 amend the preliminary relief standard in this case from the more, I would say, preferential or less burdensome standard to plaintiffs to one that's more consistent with the standard contained in the Minnesota Rules of Civil Procedure and corresponding case law. So basically bringing that standard in to a way that's consistent with the way courts already construe other similar motions. Lines 3.3 to 3.9 amend the fee award statute in cases that involve litigation. It amends the standard to be more consistent with other Minnesota civil rights standards. while also allowing individuals to recover only on the portion of claims in which they prevailed. This section also removes language allowing for changes in ward boundaries. Lines 3.10 to 4.2 add language to Minnesota law to make clear that jurisdictions can change or add polling places after statutory deadlines to address potential violations of this act. Lines 4.3 to 4.12 again require that if any change or modification is made, that notice be mailed to all affected voters of that polling place relocation if it happens more than 14 days before the election. And then finally, line 4.21 deletes the legislative findings for this act. Again, members of the committee, I'm happy to go into any of these changes or others I did not discuss in more detail, but that is a overview of the large major points that this amendment addresses.
Thank you, Mr. Erickson. I will welcome B.B. Black to testify.
Thank you, Chair Latz and members. My name is B.B. Black. I'm General Counsel for the Office of the Secretary of State. And Mr. Erickson is our expert on this area, so I have nothing further to add to his summary.
All right. Thank you. We also then have testifiers who've signed up to be heard. Michael Pernick from the Legal Defense Fund. Is Michael Pernick available?
Mr. Chair, if I might.
Senator Champion.
Michael Pernick is on virtually, but he will speak to other aspects of the bill in the event there are other questions that are raised, such as the factors and how we came up with the factors and where those factors came from.
Okay, would you, we also have Matt Hilgert who had testified. Senator Champion, do you have a preference which order we go in there?
So, Mr. Chair, Matthew is able to come forward from the cities and counties.
All right, Mr. Hilgert, go ahead and identify yourself for the record and present your testimony.
Thank you, Mr. Chair, members of the committee. My name is Matt Hilgert. I work for the Association of Minnesota Counties. AMC is an organization that represents all of Minnesota's 87 counties. I want to start by saying that counties fully understand and appreciate President Champion and advocates' concern about the outcomes of the Eighth Circuit Court of Appeals decision. I want to be clear that counties support wholeheartedly the Federal Voting Rights Act and do not oppose the protection of a private right of action. We also understand from advocates and others that it is not so simple just to put into Minnesota statute the federal VRA applies and individuals have a private right of action. And I appreciate the patience that advocates and Senator Champion have displayed to us showcasing that element. As such, our approach to this bill is hoping to do the following. We want to fully understand the case law that we are utilizing in the bill to understand what is expected of us and to have a chance to impartially defend violations that we believe do not constitute a violation or as an outcome unrelated to the powers we actually have. As members of this body are acutely aware, we are a Dillon law state, and we had a good conversation about this aspect in Senate Elections Committee. You tell us what we do. We have certain powers that we can infer when it comes to polling place location, redistricting, polling conditions such as staffing, translating services, et cetera. But we want to be clear that counties are only culpable, and cities, for the actions that we actually have control over, not state election policy. We believe that that is the legislature's obligation, not ours. The second thing that we'd like to get clarity on is the pre-suit notice process. And certainly this is something that is, I think, creative and a noble effort. I personally do appreciate this, to say that if a county or city is found or someone is letting them know that they are in violation of something, they have the ability to fix it in a good faith effort. And we believe that that is a good, noble effort to try to pursue. Right now, we still have some concerns about the attorney's fees there. So it's saying in this bill, even if we say, yes, we agree, we will fix what you've told us we need to fix, we're still going to be liable and paying up to $20,000 in attorney's fees. I will pause there, though, to thank Senator Champion, because I want to be clear, the letter we submitted last night was prior to the A5 amendment. And what Senator Champion's office did, along with the Secretary of State's office, is a significant departure from that amendment. And it does address some of our unfamiliarities with the definitions, as well as put caps in the attorney fees in the pre-suit notice process. So that was significant movement that we are very grateful for Senator Champion for. So I would close by saying that AMC and others hope to continue these conversations with President Champion and the Secretary of State's office so that we can be prepared to implement this law and continue to make Minnesotans proud of the nonpartisan professional election administration that we have in our state. And I would end there. Thank you.
Thank you, Mr. Hilgard. Now let's turn to Michael Pernick.
Good afternoon, Chair Latz and committee members. My name is Michael Pernick. I'm an attorney with the NAACP Legal Defense Fund. Thank you, as others have said, for the opportunity to testify remotely today. I also want to thank President Champion for his terrific leadership on this legislation, and the Secretary of State and his team for their critical work of moving this legislation and making sure that it'll work for Minnesota. We support the Minnesota Voting Rights Act because it addresses an urgent need for protections against racial discrimination in voting. For decades, the Supreme Court has chipped away at the protections of the Federal Voting Rights Act, making litigation under the federal VRA complex, unpredictable, and costly. And as others have said, just a few months ago, the Eighth Circuit held that voters can no longer bring lawsuits directly under Section 2 of the Voting Rights Act. The Minnesota Voting Rights Act would codify, clarify, and simplify the protections of Section 2 of the federal VRA into Minnesota state law and bolster those protections to provide for more efficient resolution of potential violations. The Minnesota Voting Rights Act will protect against voter suppression, such as, for example, polling place closures in communities of color. It'll also protect against vote dilution, such as at-large local elections that shut voters of color out of the political process, or redistricting plans that manipulate juries in a manner that dilutes minority voting strength. Now, these types of protections have existed for decades under the federal VRA. The Minnesota Voting Rights Act codifies them into state law and clarifies and simplifies the complex legal standards that have governed these claims for decades. The Minnesota Voting Rights Act will affirm Minnesota's place as a national leader on voting rights by building on the success of a growing number of states that have adopted state VRAs, including California, Washington, Oregon, Virginia, New York, and Connecticut. I'm grateful for the committee's time, and I'm happy to take questions or speak to any specific provisions of the bill, if that would be helpful. Thank you.
Thank you, Mr. Pernick. I will ask if there's anyone else in the room that wishes to testify in connection with the general parameters of the bill or the proposed A5 amendment. Not seeing anyone right now. Any questions or discussion from members of the committee on the A5 amendment? Senator Kroon.
Thank you, Mr. Chair. So with the A5 here, is it accurate to say that a plaintiff would not have a private right of action based solely on disparate impact? And so now we'd also need to pass the totality of the circumstances that the challenged law, ordinance, rule, et cetera, is related to social and historical conditions affecting members of the protected class. Am I reading that right?
Senator Champion.
Senator Chair Latz and Senator Kuhn, that's my understanding as well. I'm going to also defer to Justin Erickson just to be very specific to your question.
So, Mr. Erickson, if you would, there you are. Why don't you go ahead? Did you hear the question?
I did. Thank you, Mr. Chair.
All right. Why don't you stay visible, too, in case there are follow-up questions that you'll need to answer as the expert here. Mr. Erickson, go ahead.
Thank you, Mr. Chair and Senator. That is correct. The new language requires both proof of disparity or disparate impact, as well as an assessment of the challenge practice and how it relates to social and historical conditions. Examples of those conditions are included in the bill, though it does give some flexibility for courts to consider other conditions that they would see appropriate.
Senator Kroon.
Thank you, Mr. Chair, and thank you for that answer. In terms of what the term exactly means related to social and historical conditions affecting members of a protected class, is that language borrowed from the Federal Voting Rights Act with established case law kind of sorting through that, or is this new language? If you could help me on that.
Mr. Erickson.
Mr. Chair, and thank you, Senator. This language is largely adopted from federal case law interpreting the Voting Rights Act, case law that predates a 2021 U.S. Supreme Court decision that did, I think, scale back the protections of the federal VRA significantly. So it incorporates those pre-2021 standards while also calling out very specific circumstances that courts should consider in the bill itself as far as the relevant factors that might be considered in determining whether the social and historical factors impact or are tied to the challenge practice or qualification.
Senator Kroon.
Thank you, Mr. Chair. Thanks for that answer. You know, I was kind of wondering too, and I think the testifier for the counties alluded to this, and I'm wondering if you could elaborate. I was wondering, well, if we're just trying to get at reestablishing a private right of action to the Federal Voting Rights Act, well, you know, why would we not do our best to just recreate the Federal Voting Rights Act into state law, make it clear that we're creating a private right of action? But it sounds like that endeavor is more complicated than might originally be thought. And I'm wondering if you could expand on the complications or why that isn't practical.
Mr. Erickson.
Thank you, Mr. Chair and Senator. The Voting Rights Act, Section 2 of it, if you look at the text of it, it's really it's a fairly short piece of legislation. There's not a lot of detail to it. It's something that courts have really taken a lot of time over the years to interpret, and courts have done it in many different ways throughout the different circuits and up through the U.S. Supreme Court. And so it's not as easy to take the, I think the very limited language that's contained in the federal VRA and incorporate that into state law in a way that's effective and meaningful for courts to apply in cases brought under this act. And so what we've done is try to identify, and I think we have identified here, the standard that provides the best balance, the most meaning to both vindicating a person's constitutional rights while making sure that local and state entities are not subject to unnecessary litigation, and try to incorporate that into law using language that courts have adopted in cases analyzing this prior to 2021. And so having that standard, having that body of case law out there from federal courts will, we think, provide a good baseline for our courts to apply this going forward, while also having the guidance of the different factors that we've identified for courts to consider when addressing claims brought under this act.
Senator Kroon.
Thank you, Mr. Chair, and thank you for that answer. So this may be oversimplistic, and you can tell me if that's the case. But what I'm hearing from you is that you tried to codify the existing case law under the Federal Voting Rights Act as it existed up until at around 2021 before a recent U.S. Supreme Court case. Would that be a fair characterization?
Mr. Erickson.
Mr. Chair, thank you, Senator. I think that relates specifically to the voter suppression claim. That's where we've really focused on that. The vote dilution claim is a bit more established, I think a bit more of a consistent standard under federal case law. And so while there's a little bit more of a departure, or while there is a departure under the vote dilution claim and the voter suppression claim, they largely both are starting to track what we found under the federal VRA. But again, removing for some more recent Supreme Court decisions that we think have scaled back protections dramatically.
Any other questions or discussion from members of the committee? Senator Limmer.
Thank you, Mr. Chair. I couldn't help but look at the first paragraph of the amendment, the A5 amendment on construction and use of authority. Usually we don't put that into state statute. I was wondering why this is located in this amendment. Could someone explain that?
Mr. Erickson.
Mr. Chair, and thank you, and Senator. This is a relatively, I think, I wouldn't say unusual. It's a canon of construction that's just not been applied too frequently in Minnesota courts. It's just not an area of law that courts have had the opportunity to weigh in on too much. And so we think it important to make clear here that there is some case law that adopted it, but that case law is, I think, over 100 years old at this point. And so its relevance to different courts applying it, I think, is is hard to say how much it would be taken into consideration. And we do think it important that as courts are construing this law, that they are doing so, that they're exercising their discretion and weigh any equitable discretion in favor of the right to vote. We think it important to include that in here. And while there is some reference to it in Minnesota case law, we think that case law is so old that it's important to include it here to specifically call out how courts should address these particular issues.
Senator
Chair.
Limmer.
Mr. Chair, we've had discussion about similar provisions in different bills over the years. I always get, first, I would make a statement that I trust Minnesota judges to apply equitable discretion in how they make their decisions. Putting the words must in various places in this paragraph, I find, I don't think the judicial branch would really appreciate that much. They constantly are informing us that they are their own branch of government, and we really don't have a whole lot of right to tell them how to do things. Is this actually needed to promote your bill?
Mr. Erickson.
Thank you, Mr. Chair and Senator. I do think this is an important part of the bill. I do think this is a necessary thing to identify when we are incorporating an act that largely has not a whole lot of historical practice in Minnesota. There are not a lot of VRA claims that were brought in the federal courts in Minnesota. Certainly, there's not been an opportunity to do so in state court. I do think it important in something like this to really identify the values that are being promoted through this act, the way courts are supposed to address these issues, and the way that courts should address equities when it comes to identifying things that might be decided, whether it be matters of discovery in the litigation or other issues that come up in procedure, to make clear that we are, as we've always been, weighing these things in favor of the right to vote, as courts have recognized, and making clear that that is a canon of construction that courts adopted so long ago that the legislature chose to adopt through this action.
Mr. Chair,
Senator Limmer.
that last line, the court must exercise that discretion and weigh other equitable discretion. If I was a judge, I think I'd be insulted by seeing that. I would tend to think that our judges should be exercising that quality of discretion. Quite honestly, I just don't understand why it's so critical to the success of this legislation, but I'll let it go for now, Mr. Chair. I did have some other questions on page 2 of the amendment. I'm sorry, page 3. Change of polling place in an emergency. I see it says after the deadline on lines 312, when an emergency occurs after the deadline, and then it's to designate polling place for purpose of absentee or early voting. Could you tell me in chronological order how this would work?
Mr. Erickson.
Mr. Chair, thank you, and Senator, thank you. And I will defer to also other members of the Secretary of State's office that may be here that can speak in more detail on this particular topic. But again, there are certain deadlines for which offices or cities, counties, et cetera, have to designate polling places for purposes of absentee and early voting. When those deadlines pass, they're unable to move them. What we're trying to do here is make clear that when some change is necessary to address a potential violation of this State Voting Rights Act, that they have the discretion to do so without those administrative deadlines running in their way and without having to go through a process to change those.
I see Ms. Freeman appears to have approached here. Did you have something to add? Go ahead and identify yourself first.
Thank you, Chair. Nicole Freeman, Office of the Secretary of State. Just to add a little bit to the timeline, the deadline for establishing polling places, Senator Limmer, is December 31st of the year prior. Absentee locations are required to be designated 14 weeks prior to an election day. And so the changes made here on page 3 allow, as a remedy, for a potential violation of the Voting Rights Act, allows a jurisdiction to make changes to enact that remedy. at times other than December 31st of the prior or sooner than 14 weeks. And then you'll note too, and now I can't, back on page 4, that there also is an additional notice that is required so long as the relocation occurs more than 14 days prior to the election, if that must be mailed. If the relocation occurs, so this was placed into a section of statute that already deals with emergency polling place relocation. And so if the relocation occurs less than 14 days, there's other notice that must be posted at the prior location, on the website of the public body, and some other places that you can see up above in the paragraph. Thank you.
Mr. Chair.
Senator Limmer.
Thank you. Ms. Freeman, could you point in the bill or in the amendment where it states how this would be managed if the relocation occurs less than 14 days before an election? I couldn't find it.
Ms. Freeman.
Thank you, Chair and Senator Limmer. So I believe it's right on around 4.5 and 4.4 of the A5 amendment. The election official must notify the county auditor and the Secretary of State. The notice must include the reason and the reason for the location of the new polling place. As soon as possible, the official must post a notice stating the reason for the relocation and the location of the new polling place. The notice must be posted on the website of the public body if there is one. The local official must notify the election judges, request that local media outlets publicly announce the reason for relocation and location of the polling place. So I think everything prior to the addition in the amendment talks about what would be required.
And, Mr. Chair, Ms.
Senator
Freeman, you mentioned that there'd be a notice on the door of the previous location. You know, I remember going to a school board or a school election. I don't know what kind of referendum it was, but I went down to the local polling place and all of the polling locations had been changed throughout the entire school district. Matter of fact, people were lining up at their regular polling place and wondering why they weren't going to their next polling, or where was the place to vote. And even though there was a location posted on the door, I overheard people say, that's too far, what a hassle. And they just went home, they didn't vote at all. So I would tend to think that this would be something that would be very rarely used in that event. I did have one last question on line 3.30, designation of additional polling places. Why would one need more polling locations? I know it's in reference to section 200.54, but are we talking of more than one polling place per precinct?
Ms. Freeman.
Thank you, Chair Latz and Senator Limmer. I think that this it would, be at the determination of either a court or of a local jurisdiction as a remedy to something that was either, again, brought up in court or as part of a pre-suit notice. It could require that, yes, additional polling places be provided, whether or not that was additional polling places because the facilities were not adequate enough or the locations were not sufficient enough. So I don't want to, speculate what the situation might have been, but to say that, yes, it is a potential remedy that they would need to open additional polling locations.
Mr. Chair.
Senator Limmer.
We had this discussion in the Elections Committee, I'm a member there, about, and it was referred to as pop-up polling locations. I don't know if this is exactly the same, but the question was raised, are there any precincts in the state of Minnesota that has more than one polling location in a single precinct? Council at that time said no. My question is, well, if you maximize the number of polling locations, you very well could maximize the vote in one precinct at the expense of everyone else's. there comes a time when you have to recognize a fairness or an equality in how an election is run. If you put more than one polling place in one precinct, you have the potential of manipulating the voter turnout. So I'm very concerned about the word of designate additional polling locations. For whatever reason it might be, I would imagine if perhaps there was act of nature or something like that, that burned down the building where a polling place would be, you'd find a different location, but not an additional one. It would be a one-for-one exchange. So the way I read this, you could have more than one polling location per precinct.
Ms. Freeman.
If I could just clarify, thank you, Mr. Chair, and Senator Latz. I now realize that on 3.30, I didn't read closely enough. So Section 203B.081, Section 203B.081 does refer to temporary polling locations and polling locations that serve as absentee voting locations. So you were correct about that, Senator Limmer. And I think that the changes made throughout Section 10 are to allow a jurisdiction if a violation occurs. If a violation occurs, to remedy a potential violation of the Voting Rights Act, it allows a local jurisdiction to change a polling location both for Election Day as well as an absentee location. So I misspoke earlier about what this section was allowing someone to do, but it would allow a jurisdiction to open an additional, for 3.29 through 4.2 would allow them to open an additional place to vote ahead of Election Day.
All right, thank you.
Any further questions or discussion among members of the committee? So members, council has advised me that the A7 amendment that has also been distributed is a technical amendment and that it could be incorporated into the A5 amendment and adopted altogether. So Senator Carlson, would you move adoption of the A5 amendment incorporating the changes contained in the A7 amendment as well?
So moved, Mr. Chair. Move the A7 amendment to the, the A7 amendment to the A5? Is that what we're doing?
Yeah, Senator Carlson moves that the A5 amendment be adopted and that it incorporate the changes contained in the A7 amendment as well.
So moved.
Any further discussion? All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment as amended is adopted. All right, now we have the entire bill before us. Is there any further discussion among members of the committee on Senate File 3994 as amended? Senator Kroon.
Thank you, Mr. Chair. I'd just like to echo the line of inquiry that Senator Limmer was just raising. I mean, obviously, the intent of the voting rights is something we all can support, and I certainly do. I do get very concerned if that in the name of the Voting Rights Act, we can have more than one polling place per precinct. It seems like that in the name of civil rights, you could manipulate voter turnout pretty easily based on that. And I don't know why. I can understand changing voting precincts, but to have additional voting precincts without a whole lot of oversight is concerning, and I don't think that needs to be in this bill to advance the fundamental purpose of our voting rights.
Any further discussion? Senator Howe.
Thank you, Mr. Chair. And I guess my question would come to that, the designation of additional polling places. Can they designate those additional polling places only to remedy a potential violation of Section 200.54, or can they do it anytime they think they need one?
Senator Champion.
Thank you, Mr. Chair, and Senator Howe. Only to remedy a violation. And in fact, what it's designed to do is like the pre-suit notice, is to talk to that municipality, provide detailed information that is, articulated in the pre-suit notice, and then for that municipality to make their own voluntary decision. So no one forces them to do it. It's something, if they look and say, you know what, this is a problem. And so that will allow it for that remedy, not just because someone decides one day and wakes up and just says, I want to do more polling places. They can't do that. That's not allowed under this Minnesota Voting Rights Act.
Senator Howe.
Thank you, Mr. Chair. And so, Senator Champion, so is it an additional polling place, or is it just a different polling place?
Mr. Chair.
Senator Champion.
And Senator Howe, that would be up to that municipality. They would make that decision. No one else would make that decision for them in order to remedy that issue. And it's not designed for any other reason. There's no other manipulative notions to it. It is just to remedy a identified and agreed upon challenge.
I'm getting the feeling we're going to get additional information here, Mr. Chair.
Ms. Freeman.
Thank you, Chair Latz and Senator Howe. President Champion's answer was correct. I just wanted to point out that the changes made on lines 3.11 through page 4 are changes to both. It would depend on what remedy was chosen by a local jurisdiction. And so it could apply to a polling place, as line 3.13 says, a polling place for the purpose of earlier absentee voting, or after the deadline to designate a polling place pursuant to 204B.16, which are polling places on Election Day. So it would depend, again, as Senator Champion mentioned, what that pre-suit notice was explaining to the jurisdiction, the problem that they saw, and what remedies might be out there. The jurisdiction would then have the ability to say, we think changing X, Y, and Z will remedy the situation that's being brought to us. And then that would be, again, as Senator Champion said, articulated out to the county auditor, our office, as well as posted how they're using a change of polling location, whether on Election Day or absentee voting location, to remedy the violation of the Voting Rights Act that was prescribed to them in that pre-suit notice.
Senator Howe.
Thank you, Mr. Chair. I lost it in someplace in there, so help me bring it down to maybe not so quite so much verbiage.
Sure.
So is it an additional, or is it just changing?
Ms. Freeman.
Thank you, Senator Latz and Senator Howe. So either the change or potentially an additional location. The additional location would be related to absentee voting locations. The change of polling place would be related to Election Day. And the reason for that would be, so a part of the bill is that someone who feels that they have a member of a protected class feels that they have either had experienced voter suppression or vote dilution. They must provide, except for a few certain circumstances, a pre-suit notice to the jurisdiction. This pre-suit notice is like a letter that explains their grievance. The jurisdiction then can choose to engage in that pre-suit notice process. And again, depending on what the allegation is, if it revolves around a polling location, this allows a jurisdiction to make a change to a polling location, which they're allowed to do under current state statute, but it allows them to make that change outside of the deadlines that exist in state statute.
Senator Lummer.
Thank you, Mr. Chair. Ms. Freeman, would you would you agree with the characterization that Senator Champion stated, that every political subdivision has the power to apply this principle in their own manner?
Ms. Freeman.
Thank you. I think that what Senator Champion was getting at is that when a jurisdiction receives a pre-suit notice, they are able to engage with the party that sent them that notice and can come up with solutions that might be potential remedies. And so I think what Senator Champion was getting at was that there are a lot of there may be a lot of options for remedies, and so the jurisdiction is going to know. What remedies might be available to themselves based on, just based on their own individual circumstances as a jurisdiction.
And Mr. Chair, if I might,
Senator Champion.
I think it should be clarified is that with a pre-suit notice that goes out that is detailed to a political subdivision, it should be detailed enough so the political subdivision can make a decision. A political subdivision can say, I don't think there's a violation. I'm not doing anything.
Mm-hmm. Yep.
There's no one that can make them do anything. Not at all. So I don't want this to come across as if they get this notice and then they have to do something. They make that decision as to whether they want to do something or if they can clearly identify that there is a potential violation and make that decision as to how they want to remedy it themselves or not do anything. So I just want to make sure that it's clear that we do not usurp, preempt, take away from any political subdivision, nothing at all. And what is different about this is the pre-suit notice, because we want to make sure that there's engagement and talking before people go into expensive litigation and start doing other things. That's all it does. So it does not require anyone to do anything. It doesn't require them to change anything if they don't think they should. It doesn't require for them to do to put forth an additional polling site. None of that. They could just say, I don't agree. So I just wanted to make sure that that was clear. Thank you, Mr. Chair.
Mr. Chair.
Senator Limmer.
A few years ago, when we opened up the 45-day voting period, I believe the city of Minneapolis kept their balloting open for early balloting on Sundays. There was no restriction in the law for that. Everyone else in the state presumed that balloting would be closed on a Sunday. Minneapolis took advantage of that seventh day, and over a 45-day period, there was 6 extra voting days in the city of Minneapolis and nowhere else in the state. So I would really stress that we would make standardized rules and not have a collection of patchwork possibilities on election rules. That's what I'm concerned about in this bill. So, Senator Champion, you're basically saying they can apply these rules or they don't have to. And now we get the patchwork again, and in some political subdivisions, there is a definite advantage to give a city like Minneapolis 6 to 7 extra days to drive the vote for the ultimate November election result.
Mr. Chair,
Senator Champion.
briefly. Thank you, Mr. Chair and Senator Limmer. Senator Limmer, I hope that you would bifurcate these issues and not conflate them. And I believe, unfortunately, that you are conflating them. The issue that you have outlined, whether it's an issue or not for the city of Minneapolis and what happened in the 45 days period, that is a different notion. What this bill is about is if there's an allegation of voter suppression or voting dilution, there has to be some articulation, and the only way a person or municipality under this law is able to change or prescribe to do something is if there is a perceived violation. It is not, and I repeat, Senator Limmer, it is not to just say to others, city of Minneapolis, others like, without any reason, just for them to go out and say, you know what, I'm going to put in some additional polling places. That's not this piece of legislation. The issue you're talking about is something other than this. I recognize how important it is to be very careful, but again, it is narrowly tailored in order to give someone a private right of action because of voter suppression or voting dilution. And there's some detailed information that must be provided in order for that municipality or political subdivision to decide if they agree with what has been put forth. If not, they don't have to do anything. So I just hope that we would separate those two important issues, and I'm not recognizing that your issue is not important, but that's not covered here.
Senator Kroon.
Thank you, Mr. Chair. It seems like local governments do have quite a bit of discretion in deciding whether or not to add polling places in response to an allegation of a violation of this act, voter suppression or voter dilution. I guess my question is there a mechanism in this bill that would give someone else standing to challenge whether or not a local government has properly exercised that discretion?
Senator Champion.
Thank you, Mr. Chair, and thank you, Senator Kroon, for that question. And any of my testifiers can correct me if I'm wrong. But it's my understanding that if there was going to be some, so first of all, no, I don't think so. If someone has a perceived violation of their own that has nothing to do with someone who's the subject of this, they could intervene as like they could put forth a brief, or they can say, hey, here's what has happened in the past, or some things that they've done that one should look at. But again, you will not have standing to speak on my behalf. I have to be the person who says I am harmed in this way, and then there is naturally a group and others who might say, hey, we think that this is a potential violation, and they have to demonstrate that, right? And so, again, it's the private right of action. That's what we're getting to. That's what we think is important, because we believe that voting is important, and we don't want any barriers to be created that would prohibit groups of people based on race and other things from voting.
Senator Kroon.
Thank you, Mr. Chair. I'm just trying to get at, obviously if there's legitimate violations of this, we want to rectify that. I'm not disputing that or wouldn't want to do anything to suggest otherwise. I guess I'm just trying to get at a scenario where you have, let's say, I'll just give an example. Let's say you have a left-leaning political subdivision and there's a complaint, and their solution is we're going to add 2 more polling places to the precincts that historically vote Democrat, and we're going to leave the precincts that historically vote Republican with just 1 polling place. Would the Republican Party or somebody have an opportunity to step in and say, no, there's actually no violation of the act here, and what you're doing is just trying to drive turnout, you're trying to manipulate turnout in Democrat areas? Would there be any opportunity for standing for somebody like that to jump in and say, this local political subdivision is abusing its discretion under this act?
Senator Champion.
Mr. Chair and Senator Kroon, so one, I always think it's interesting that you use left wing instead of right wing, so that's always interesting to me, but I get it, right? What I will say is that a political subdivision, which is supposed to be neutral, they are not right-leaning, left-leaning, leaning at all. Once they're there, when they're election judges or there's this municipality, they recognize that they represent both left-wing folks who have left-wing ideology as well as right-wing. So they are supposed to be objective. So I have trust that they would do that. There's nothing in this bill that would just say, for the purposes of giving someone an unfair advantage, that they should add any polling places or absentee polling places. What is true is that once that information is provided, that there is a perceived problem or challenge or concern, that municipality or political subdivision, which is neutral, can make a decision as to whether they agree or disagree. And if they don't agree, they can blow the other person off and say no. And so there's nothing, again, I'm underscoring this, nothing that would give anyone the discretion to just do things in isolation as a way of, as you mentioned, to increase voter turnout. I would hope that we would try to increase voter turnout no matter what, because we understand that voting is the bedrock to our democracy, and that we want people to come out and vote, right? And we want them to vote, and we want them to be informed. And so I believe that a person to be able to talk to their political subdivision if they believe that there's something not going on that they have an opinion about. But we do have people who represent us, which is in those political subdivisions where they're neutral and objective and would make a important decision.
So members, we're going to draw this conversation to a close here as we still have a long agenda ahead of us. Any further discussion or questions? Senator Westland.
Sorry, I think we've gotten a little lost here, so I just want to try and clarify this. This entire section is about a change of a polling place in case of an emergency. What's being added to this is that the change in polling place could be as a result of a potential violation of 200.54. 203B.081 deals only with absentee voting locations, right? And this is about emergencies that are occurring after the deadline, and it provides the opportunity to provide additional absentee or early voting locations under those circumstances. The change in polling places in subdivision 2 goes back to 204B.16. That is not adding a polling place, that's saying it's changing a polling place and changing that location based on a potential remedy for a violation. The designation of additional polling places in 2A, again, goes specifically to additional absentee voting and early voting. We are not adding polling places on Election Day.
There being no further discussion on Senate File 3994 as amended, Senator Carlson moves that Senate File 3994 as amended be recommended to pass and be sent to the Senate floor. All those in favor say aye. Aye. Opposed? Motion prevails. Now, we have Senator Champion, you're going to have to forgive us, but we've got another bill where the testifier, the chief author, has to leave.
Okay.
Because
I'll move over and wait, Mr. Chair.
So we'll come back to you after this next one is done. Thank you for
Absolutely.
your
Thank you, Mr. Chair.
consideration here. Senate File 4342, Senator Swedzinski is coming forward to present this bill. And members, you do have this packet has been distributed to you. Senator Swedzinski, welcome to the Judiciary Committee.
Thanks for having me. And I want to thank Senator Abe. This bill does have bipartisan support, so I'd like to publicly acknowledge Senator Housley and Gustafson, Duckworth, and Abler on this bill. A couple of years ago, I went on a ride-along with Hennepin County EMS, and you know, this is a guy, me, that grew up with the Norman Rockwell painting of the little boy in the middle of a parade staring up at this police officer with nothing but admiration and respect and awe on this young boy's face. That's the image I grew up with. Well, I went on this ride-along, as I said, with EMS Hennepin County, and emergency after emergency after emergency, I sat there watching this one official, and finally at some point in the evening I asked him, how do you go home and shut this off? And he looked at me and he says, I don't. And I didn't know what to say, because it really bummed me out. And with that said, when Senator Housley approached me to co-author this bill, I jumped at it. And what the bill does is it basically provides therapy dogs for officers that are suffering from job-related trauma and post-traumatic stress. And it's a great idea, and a couple communities have already found that therapy dogs for the police force serve as much of a source of wonder as dogs that are their sole purpose is to find drugs and go after people in bad situations. So anyways, that's the bill. That was my impetus in co-authoring it, and I'm here to answer any questions.
Thank you, Senator Swatzinski. We do have a testifier for the bill, Melissa Miller-Hurley, who I believe is online here from the Pet Advocacy Network. Ms. Hurley, go ahead. Thank you.
Yes, thank you so much for your time, and thank you, Chairperson Latz and members of the Senate Judiciary and Public Safety Committee. My name is Melissa Miller-Hurley. I'm the Vice President of Government Affairs of the Pet Advocacy Network, and we represent the interests and expertise of the retailers, companion animal suppliers, manufacturers, pet owners, and others that are involved in all the aspects of pet care across the U.S. So we're really the advocacy voice of the responsible pet care community, which is why we were so excited to see this bill and see the initiative that Minnesota is taking. We know firsthand that therapy dogs are known for their ability to provide comfort, companionship, and emotional support. And we've seen the studies that have shown that these interactions with therapy dogs can significantly reduce stress, anxiety, and symptoms of PTSD. And they can also just kind of provide that pause in the day that so many of our first responders need, that allows them to take a breath, put a smile on their face, and be able to really decompress, even if it is for 5 minutes. We know that law enforcement officers especially encounter high stress situations and trauma, and that the presence of these therapy dogs can play a crucial role in helping to mitigate any long-term psychological impact of their work. And so that's why we think this initiative is such a crucial step towards addressing those mental health challenges faced by peace officers who are often exposed to traumatic incidents during their service. And as the Senator just spoke about, it's nonstop when they're on. And so as the advocacy voice of the broader responsible pet care industry, we also work with and support therapy animal nonprofits across the country. And we're able then, through our work with that, to witness the firsthand positive experience that therapy dogs can have on individuals experiencing job-related stress, trauma, and PTSD. And again, we know law enforcement officers in particular face unique and demanding challenges that can take a toll on their mental well-being. And so we really think that the introduction of therapy dogs into their environment can serve as an invaluable tool to supporting their mental health. We also were really pleased to see that this bill included the ability for therapy dogs to go on calls relating to emotional distress. In calls like this, we know that emotions are high. We know that folks are stressed. We know that people may not be thinking entirely clearly. And we also know that the calming influence of a therapy dog can de-escalate tense situations and create a safer environment for both the officers and individuals that they're assisting. In addition, before I, talk again about how excited we are, therapy dogs and animals help bridge the gap in communication between police officers, police departments, and the communities. And they help establish trust between law enforcement and the communities that they serve. We've already seen positive impacts in communities that have formed kind of these outreach animal programs. In 2019, after the success that Troy, Michigan found when they created their position for a cat they adopted called Officer Donut, City of Fort Smith in Arkansas brought in their own department cat named Officer Fuzz with the goal of explicitly bridging communities with fur and friendship. And so we've seen these just positive impact, and we've seen kids' faces light up when these cats, when these dogs that are really liaisons for the police department have had when they come into classrooms, when they come to community events. And that's, again, why we think this kind of program would be so unique for the state and could really help possibly set forth other states and provide an example for it. We think that the proposed grant program to work with trusted nonprofits that teach, train, and provide therapy dogs is a great way to ensure accountability and a great way to kind of get this up and moving as quickly as possible. We work with a lot of these nonprofits. Every year we bring these animals to Capitol Hill, and we kind of have a pet therapy day on Capitol Hill. And you wouldn't believe just the reception we get. And these are just political staffers who are coming in and saying how important it is.
Ms. Miller-Hurley, I'm sorry, but I'm going to have to ask you to wrap up. We have a long agenda today, and we're focusing on law enforcement.
Yes. again, and that was just an example of how important it is and how we think this would be such an important step for law enforcement, because we know how unique their jobs are. We know how unique the stress level is. And we know that this bill would provide the emotional support animals and would provide an outlet to be able to make sure that when officers are going home, they're able to do so hopefully in a much more positive manner, and they're able to use these resources to make sure that we're keeping their mental health strong and we're keeping their care for themselves strong, because that's the best way we can continue to serve the community, by having strong officers, by having strong mental health, and allowing that to really work in our favor. And so we really
Thank you, Ms. Miller-Hurley.
bill.
Appreciate your testimony today. Is there any discussion among members of the committee on this? Senator Howe?
And I don't need an answer. I'm just, the only concern I have is it is just for law enforcement. Coming from the fire community and the public safety community, I think it should incorporate more than just law enforcement, but I'll leave that to you folks.
Any other discussion? Members, we're going to lay over Senate File 4342 for possible inclusion in the Judiciary budget bill.
Thank you, Mr. Chair and members.
Thank you, Senator Swedzinski. Senator Champion, we'll bring you back now for Senate File 4714 on expungement.
Thank you, Mr. Chair, for bringing me back. Senate File 4714 really just seeks to do a couple things, and I do have a testifier in the event that you have anything that you want to ask him. As you know, that last year the Minnesota Clean Slate Act of 2023 was enacted into law that talked about automatic expungement for offenses that already qualify for expungement under the current petition process. We recognize that there were a couple of things that we need to do as updates and to clarify some things for the court. And this bill seeks to clarify the offenses of reckless driving resulting in great bodily harm or death will be ineligible for automatic expungement. We also exclude burglary in the third degree other than trespass as eligible for automatic expungement. And we make clear that the waiting period before a person can petition for expungement is 4 years for certain cases involving a stay of imposition. And last but certainly not least, it clarifies that certain offenses related to offering a forced check will be eligible for expungement. And I think there was also, we do also have a technical amendment that is a correction to the Clean Slate Act that was a drafting error, and that is what this bill will do. And we hope that this committee will include it or lay it over for possible inclusion. And I have my testifier from the Ramsey County Attorney's Office if he has anything additional that he would like to say briefly.
Thank you. This is the first stop for this bill. Senator Umu Verbatim moves adoption of the A1 amendment as an author's amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. We have our backup testifier in case there are any questions. Anyone else in the room wish to testify in connection with this? Not seeing any. Any questions or comments from members of the committee? Not seeing any there either. So Senate File 4714 will be laid over for possible inclusion.
Thank you.
Thank you, Senator Champion.
Thank you.
All right, members, we're going to move to Senate File 1743 on midwife licensure. Senator Boldon.
Thank you, Mr. Chair and members. I am pleased to be here to present Senate File 1743, the Minnesota Certified Midwife Practice Act. This is a bipartisan bill that builds on the successful model of certified nurse midwives who have been serving in Minnesota for over 50 years. It would allow professionals to follow a pathway through the graduate midwifery education and into midwifery practice without the added time and educational costs of first obtaining a nursing degree and licensed that a certified nurse midwife requires. The United States and Minnesota have a maternal health crisis that is causing high levels of maternal mortality and morbidity, stark racial disparities, and large areas of greater Minnesota to be considered maternity care deserts. The consequence of this crisis is well documented in the materials that are in your packets, committee members.
One step that Minnesota can take this year to address this crisis is to implement certified midwife licensure. This is an evidence-based strategy that we can implement to expand and diversify our midwifery workforce. Certified midwives are not new to the United States. They are practicing in 12 other states, and they have been practicing in some states for upwards of 30 years. Passage of this bill allows professionals to become a midwife first without first becoming a registered nurse. To graduate from a certified midwife program, a candidate will have to complete the same science prerequisites, will have the same graduate level midwifery education, and pass the same certification boards as nurse midwives. The midwifery scope of practice for licensed certified midwives will be the same as certified nurse midwives. This bill will also help ensure that the precious registered nurse educational seats will be reserved for those people who genuinely want to be nurses. The Board of Medical Practice and the Board of Nursing support certified midwives being licensed under the Board of Nursing to ensure consistent application of the regulatory requirements. And staff at the Board of Nursing, I want to thank them. They've worked closely with us and supporters of this bill in drafting to make sure that all of the relevant regulations were included. In conclusion, the University of Minnesota is poised to start a certified midwife program in the University of Minnesota midwifery program, but they don't want to start that program until graduates can gain licensure upon graduation. So there are folks who are ready to jump into this role. There are no opponents, and many supporters have submitted letters that are included in your packets.
Thank you, Senator Boldon. Members, we're going to focus our consideration today on the provisions in Senate File 1743 that are within the jurisdiction of the Judiciary Committee. Ms. Primo, would you please identify those for us?
Mr. Chair and members, those would be sections 15 through 20. Section 15 begins on page 9, and then sections 22 and 23.
So the sections dealing with disciplinary action, license suspension, and reissuance, reporting obligations, immunities, cooperation with investigation, a disciplinary record on judicial review, and then violations and penalties, and consequences for unauthorized practice of midwifery.
Mr. Chair. Mr. Chairman.
Senator Pappas.
Thank you, Mr. Chairman. Just a question. I assume that these mirror what we already have in law for nurse midwives?
Go ahead and identify yourself for the record. You can answer the question.
Thank you, Mr. Chair. Thank you, Senator Pappas. I am Mandy Huber, nurse midwife. I am representing the American College of Nurse Midwives today. Senator Pappas, you are correct. This is a mirror of the Nurse Midwife Practice Act. There is only one novel statement in here that has not been in statute elsewhere, and that is to clarify that traditional midwives are not subject to this statute. They have their own independent statute.
Thank you.
All right, members, we do have a technical A1 amendment that council has asked us to adopt. That's being distributed. And Mr. Backus will explain it.
Thank you, Mr. Chair and members. When reviewing the bill, there's a provision on page 12, subdivision 2, that addresses individuals who have been convicted of sex offenses. When reviewing it, it became apparent that the statutory references were to the criminal sexual statute provisions from before the 2021 recod. So this essentially just updates those provisions.
Senator Pappas.
I would move the A1 amendment.
Senator Boldon, any position on that?
Thank you, Mr. Chair. I appreciate the eagle eye of Senate Counsel to help us with this and would support the amendment.
Senator Pappas's motion adopting the A1 amendment. All those in favor say aye. Aye. Aye opposed. Motion prevails. The amendment's adopted. Is there any other discussion regarding any of these provisions, or do we have any testimony that we need to hear further to focus on the provisions before this committee? Anyone else in the room want to testify? Any questions or discussion from members of the committee? Not seeing any. Senator Pappas moves that Senate File 1743 43 as amended be recommended to pass and be re-referred to the Committee on Health and Human Services. All those in favor say aye. Aye. Opposed? Motion prevails. Thank you, Senator Boldon.
Thank you, members.
We saw Senator Anderson here earlier. Is he? Oh, there he is. Senator Anderson, you're up next. Senate File 4005. Come on forward. Members, the packet will be distributed here by staff. Senator Anderson, why don't you go ahead and tell us what the bill's about? Oh, before I do, I'll tell you, members, the plan here is to lay this over for possible inclusion in the Judiciary budget bill. Senator Anderson.
Thank you, Mr. Chairman. Thank you, members of the committee. Appreciate the opportunity. I have with me two testifiers on behalf of the bill. The bill is titled Appropriating Money for a Grant to Beltrami County for a Comprehensive Mental Health Services Program, which would deal with a diversion center for individuals under arrest or subject to arrest in Beltrami County or northwestern Minnesota. Mr. Chairman, members, this bill is a bill that's been circulating for quite some time. As I look back in history, I recall that Senator Ingebrigtsen and myself signed on to a clone bill that Senator Barb Goodwin had brought forward in 2015, and she had brought two bills that were to be, one was going to go to meeting the needs of the Comprehensive Mental Health Services Program, and one was to go to help with the Beltrami County Social Services, Health Services grants. And so this is a request, the request at that time was for $8 million to help in meeting the out of the general fund for a grant to Beltrami County. But I would like to have the testifiers testify on behalf of the bill and their needs for this ongoing opportunity.
Senator Anderson, we have a couple of people signed up to testify here, Ann Linseth from Beltrami County and Megan Hansen. Do you have a preference which order we go in?
Yes.
Who would you like to have testify first?
The testifier, Ann Linseth
All right.
and Megan Hansen.
Okay. Ms. Linseth, welcome to the Senate Judiciary Committee. If you could go ahead and identify yourself for the record and your affiliation, and go ahead and present your testimony.
Thank you, Chairman and subcommittee committee members. My name is Ann Linseth. I'm the Director of Health and Human Services for Beltrami County. And I would like to share a little bit about Beltrami County's behavioral health needs and the definite need for this funding resource. So in Beltrami County, both our community and our jail see very high rates of behavioral health challenges, which I understand is similar to many areas of the state. But unique to Beltrami County is our strong collaboration with our community partners. We work together to improve and increase service availability that is accessible and culturally appropriate. We have about 20% of our community that is Native American, and we continue to seek ways to increase culturally based programming and services. As a community, partnering with numerous agencies, our region has created already a service array to support people with behavioral health challenges, which I'm going to allow Megan Hansen from Sanford Health to speak to a bit more than myself. Beltrami County serves as a regional hub to approximately 100,000 people. We have high rates of poverty. Unfortunately, we have the second highest poverty rate in Minnesota. About 19% of people here live in poverty, and only 30% of our land mass is taxable. And so the reason I tell you that is that I want to illustrate our region does not have a lot of resources. We have creatively utilized the resources we do have to improve our behavioral health services, and we've done so quite successfully. But unfortunately, our area is not immune to the systemic challenges in adequately serving people with behavioral health needs. There are gaps in our region's service array that could be addressed through this funding for resources, planning, and development. And we do have the invested partnerships to be successful, which we are very proud of those. In the last 10 years, Beltrami County has built up behavioral health services despite the significant barriers that I already mentioned, as well as additional barriers such as programmatic funding, reimbursement rates. We have about a third of our community members who receive medical assistance, and also our staffing challenges. As I know in many other areas of the state, we see those staffing challenges. Despite these developments, the behavioral health system that we do have is fractured. And due to our region's poor social determinants of health and that fractionalized system, there continues to be some areas that need more services, including the population identified in this bill. In our jail, there's a lack of treatment, interdisciplinary services, and competency restoration programs. We also need to look more into the co-responding model that could be developed in our area, as well as additional diversionary programs. We would also like to explore how to create support systems between responders to strengthen our workforce in behavioral health. Beltrami County and our partners are ready for the next steps in evolution around behavioral health. We have the beginnings of a successful and sustainable behavioral health partnership, but we need funding and resources to support this full continuum of care. If we have a person who is experiencing a psychotic episode, and we could develop the services to divert them into appropriate treatment instead of holding them in the jail, we're serving the person and we're also serving the whole continuum of care. This funding has the possibility to support Beltrami County's behavioral health population, our programs, our staff, and all the individuals in our community. So I would like to just show my full support for funding for Beltrami County for Senate File 4005. And with that, I think I'll hand it off to Megan Hansen from Sanford Health.
Thank you, Ms. Linseth. Megan Hansen, go ahead. Welcome to the Judiciary Committee.
Thank you, Mr. Chair and Subcommittee. My name is Megan Hansen, and I am a director within Behavioral Health of Sanford of Northern Minnesota. I'm a clinical social worker by training and have been employed by Sanford Health of Northern Minnesota for over 7 years. As Ann mentioned, Sanford Health has been a strong partner and collaborator with Beltrami County for many years. We offer a number of services across the behavioral health continuum of care. Sanford Health as a whole is committed to addressing the needs of our community, which includes addressing social determinants of health, creating culturally responsive and sustainable services that are evidence-based and trauma-informed. Over the past 1 to 2 years, we have been closely working with Beltrami County to develop a program to support inmates who are experiencing mental health or chemical health needs. This program is titled EMBER, which stands for Embrace, Motivate, Believe, Execute, and Remedy. We are starting this on a small scale in the upcoming months, and it is going to be focused to treat the most ill of inmates. One of the largest hurdles that we've had with this project rollout has been locating a sustainable way to fund this, as we want to bring forth clinical therapy, assessment, psychiatry, and substance use treatment into the jail. This is only one example of a recent idea that our community has come together on to care for this population. We are motivated towards additional creative and innovative ideas that meet our community members' needs. We see room for improvement and expansion in a few of the following areas that this bill could support. Those include prevention, looking at how do we best engage individuals at risk of incarceration and work to reduce recidivism. This could include expansion of services such as care coordination, peer support, skills-based support that would meet these individuals where they're at, oftentimes in the community. Bringing the service directly to the individual is helpful in this case, as they often do not have reliable means of transportation, especially in rural Minnesota. When we look at intervention growth, we currently, as I mentioned, are in the beginning stages of rolling out EMBER. Expansion would allow us to explore plans to bring this type of service approach to other programs that fits the needs of those who are at risk for incarceration or have been incarcerated. Last year, Sanford opened their first empath unit, which is a psychiatric emergency room. The one unit that Sanford Health as a whole holds happens to be located in Bemidji. We've had to limit the hours of operation due to financial constraints, but with additional funding that this bill could offer, we would envision operating this unit 24/7. This would allow for a safe place for individuals to go who need to receive immediate supportive behavioral health services, which would create an opportunity to, again, reduce or prevent incarceration. Also in 2023, Sanford of Northern Minnesota opened its first Youth Act program for ages 8 to 15. If we had additional funding, we would be able to create a ACT program that would also support ages 16 and 17 to help with reducing the youth impact of entering into the criminal justice system as an adult. As Ann mentioned, we continue to have long waits for some of our services within the community due to lack of funding to hire additional staff, as well as difficulty recruiting to rural Minnesota. This funding could help us reduce service wait times of the programs that we do have and look at better ways to utilize the continuity of care and collaboration between the individual and their interdisciplinary treatment plan, which is often key to successful outcomes. Competency restoration programming is very limited in our community, but with additional funding, collaboration, and resources, I am confident that our community could develop a program that would meet our consumers' needs. Thank you for your time today. We appreciate your investment in this bill, along with behavioral health in our community.
All right, thank you for your testimony. I know I have a question, maybe Senator Anderson can give us some information on the financial history relating to this proposal, because my understanding is that there, in 2015, there was some money passed. There was supposed to be, the local groups were to find some money to keep the program going. That didn't happen, the program expired, and now they're back asking for more. So maybe you can help us understand what the history is here. Senator Anderson.
Well, Mr. Chair, the Senate file that was introduced by Senator Goodwin at the time asked for $8 million, and it was passed by the House and the Senate and sent to the governor's office. The $8 million was the line item vetoed at that time, and $500,000 was provided to any county at that time. The bill, the way it was written, was to any county that would want to come forward and take advantage of the opportunity to invest in this and take advantage of the grant fund. So Sanford Health, as was testified to, they at that time were awarded $500,000. That's not enough to put forward a facility, and yet they said at the time, I recall, that they had land right next to their medical facility that could be added onto as a mental health facility to help in meeting the need that I find my law enforcement officers, both the city of Buffalo and Monticello and the county of Wright, are looking for opportunities to take people who have mental health challenges to get some analysis done quickly without having to go as far as Fargo, North Dakota, and beyond to have to use a manpower to escort these individuals who are been incarcerated. So that's kind of the background of how the money was put forward at that time. And I introduced this same bill back in 2022, and we're going to continue to try and meet this need, because I not only hear from my law enforcement officers, but other law enforcement across the state that are looking for facilities within the state of Minnesota to meet their need. I know that Senator Senjum, back when he was still with us, signed on to my bill in 2022 or 2021. Can't remember the actual year, but they also received financial, and I think in the capital investment bill, to put up a facility in the Rochester area. But we're trying to spread this out to make sure that we have an opportunity in other areas, and whatever county would be willing to take and be a part of this, and other private, like Sanford Health, who would be willing to come alongside the county and assist in meeting this need.
So Senator Anderson, I've no doubt, and I think we've hard pressed to find anyone who would doubt that there is a lot of unmet need for mental health services in Minnesota. And to me, the question becomes what model of funding should be used to meet those needs? How much state level funding, how much local level funding? And should it be coordinated in some way as well? And we'll have an opportunity at some point, members of this committee, to hear some proposals for at least having a statewide coordinator on mental health issues. But we have this proposal in front of us. I am informed, Senator Anderson, that it might have been $2 million, not $500,000. That was distributed in that grant program back in 2015 or 2016. But, whatever the number, it appears to have run out. Do you have any idea what the local match or funding has been on this as well? Because, the state's not going to be in a position to fund all the mental health services in the state of Minnesota like this. Do you know?
Mr. Chair, committee members, I do not know if they have come forward with a match or request for a match on the funding. I know that in talking with the Ms. Linseth, that their funding is very much strapped because of the small population that they have within the county. And they have also a Native American territory area within that is part of their jurisdiction, but it eats up a lot of their finances. So that combination of both really restricts the amount of money that they have, and they are looking forward to any help they can. They're willing to come forward with an offer, but it won't be a large amount.
All right. Anyone else in the room wish to testify in connection with this? Any members of the committee have any questions or comments? The plan is to lay it over for possible inclusion. All right, Senator Anderson, thank you very much. Senate File 4005 is laid over.
Thank you, Mr. Chair. Thank you, members.
Members, next up, Senator Carlson, Senate File 4272. And we will invite Director Hansen from the Office of Traffic Safety to come forward as well to provide testimony.
Three bills are being handed up in this set.
The members, you're getting packets for the remaining three bills on the agenda being distributed by staff at this time. Senator Carlson, why don't you go ahead while we're getting our packets and tell us about the bill.
Thank you, Mr. Chair. I have Senate File 4272, which is an agency bill, and what it does is it clarifies how search warrants can be handled between adjacent states. And it clarifies and also clarifies and defines search warrant a bit differently. And this is its first hearing, and I do have an A1 author's amendment.
Senator Carlson moves adoption of the A1 author's amendment. All those in favor say aye.
Aye.
Hold on a second. We'll get it handed out before we vote. Now, Senator Carlson moves adoption of the A1 author's amendment. All those in favor say aye.
Aye.
Opposed, motion prevails. The amendment's adopted. Senator Carlson, order your testifier, Director Hansen.
Thank you, Mr. Chair. And I have Department of Public Safety Director Hansen to describe in more depth what is happening here with the search warrants and the interstate actions for both stoppages, testing, and the locations where the offense has occurred.
Okay, members, my understanding is that our committee passed this last year, and for some reason it didn't get across the finish line. I think the House maybe didn't move it along. So Director Hansen, you can be short and succinct and explain why we need this.
Very good. Thank you, Mr. Chair and members. And yes, I will be very brief. Basically, what we're looking for here is a technical correction to the search warrant language as it applies to a impaired driving investigation. Basically, what happens now, if a driver is involved in a crash and they are injured and they're treated at a hospital in Minnesota, and if impairment is suspected, law enforcement will have a search warrant drawn up and will be approved by a judge, and that test is then taken at the hospital. Test is sent to the lab, the analysis comes back, and if that analysis does show that that person was under the influence, that result is sent to Driver and Vehicle Services, and there's an immediate driver's license revocation. Now, the scenario that we're trying to correct with this technical correction is if that driver happens to be transported to a medical facility outside of the state of Minnesota, and based on my own work experience, if you're in the western third or quarter of the state, you're going to go to Grand Forks, Fargo, or one of the hospitals in South Dakota in order to be treated at a trauma center. Now, the same scenario applies there. If impairment is suspected, law enforcement needs to obtain a search warrant, and this goes back to a couple of Supreme Court cases, in order for us to obtain that test from that driver. So what Minnesota law enforcement does is they partner with the agencies across the border to have a search warrant drawn up in the state where the test is to be taken from. So either North Dakota, South Dakota, Iowa, or in some cases, Wisconsin. Now, that same process follows. The search warrant is executed, the sample is obtained, the sample is sent into the BCA, and this is where the difference is. If that result comes back and indicates that that driver was impaired, that result may still go to Driver and Vehicle Services, but because of the technical language in 171, 177, that is not reportable to Driver and Vehicle Services for the purpose of revoking that individual's driving privileges. So we have two drivers, one that is treated in Minnesota that is subject to an immediate revocation when that test comes back, and that same driver who happens to be treated out of state will drive for upwards of a year before any sanctions can take place, because that revocation then is dependent upon a conviction for the offense. So what we're simply asking for is a change in the way that a search warrant is described in the statute, and that will expand it out and allow that test to be reportable to Driver and Vehicle Services, which will trigger that license revocation, which we know is one of the most significant things to preventing recidivism, and is one of the stronger motivations for persons not to drive impaired. And with that, Mr. Chair, I'd be more than happy to answer any questions that your members may have.
Thank you, Director Hansen. Any questions from members of the committee? Anyone else wish to testify in connection with this in the room here? Senator Howe.
Thank you, Mr. Chair. And Senator Carlson, because this was my bill 753 last year, would you mind having a co-author? Other than that, I don't have any concerns.
Mr. Chair, absolutely.
Senator Carlson.
Senator Hall.
All right, love the bipartisan love fest going on here. All right, so members, we are going to lay this over for possible inclusion in our omnibus bill. Thank you, Senator Carlson.
Thank you, Mr. Chair and members.
Senator Pappas. Thank you, sir. Senate File 3987.
Mr. Chairman and members,
Senator Pappas.
this legislation is kind of a follow-up from last year's where the Office of Restorative Justice was established. But the goal of this bill is to address the burden of fines and fees on children and families in the context of our juvenile justice system. By charging fees and fines, the justice system drowns youth and their families in debt. Ultimately, this system undermines community health, economic stability, and trust in public systems. The impact of fines and fees are long-lasting in the lives of young people. Those who cannot pay for fees and fines face extended probation, additional court visits, the loss of or inability to obtain a driver's license, or even incarceration. As they age into adulthood, they could face civil judgments, tax and wage garnishment, and bankruptcy, any of which can impact their credit and eligibility for student loans, rental leases, or car loans. So the bill addresses this in several ways. First, it encourages the use of restorative processes to satisfy the restitution obligation where available. It permits the use of the restorative practices grants that were created in 2023 for the purposes of obtaining monetary compensation to satisfy restitution obligations of a child who participates in a restorative process to address harm. It eliminates several fines and fees in the juvenile justice context. Notably, these fines are not ordered and are collected at levels that this would have a meaningful impact on court revenues. The bill will provide additional avenues for a meaningful, victim-centered, community-supported work service that helps the youth understand their actual impact on the community. For example, by cleaning graffiti off a business owner's wall, they actually see and feel the impact they created while removing it, rather than a fine that may be administered 6 months later when the youth has kind of forgotten about it and tried to move on with their life. So the goal of a restorative process is to unpack the harm that was caused by the person's actions and attempt to make the victim whole to the extent possible. That's why restitution is an important component, particularly for people who have suffered a monetary loss. Mr. Chairman, I have with me two people on Zoom, Morgan Coons, the Hennepin County Attorney's Office, and then also Sharon Hendricks, the Director of Yellow Medicine County Restorative Justice Department. They've been kind of the pilot program that has proven how successful restorative justice can be.
Thank you. Before we do that, Senator Pappas, there is an A1 author's amendment. I'm told that you would like to add to the bill. We'll have that distributed right now.
Mr. Chairman, the A1
Senator
was
Pappas.
added in the House, and maybe Council could explain what it does.
It's an author's amendment, Senator Pappas, since this
Okay.
is your first stop.
All right.
You certainly can have counsel explain it if you wish.
I have it.
Mr. Backus, why don't you tell us what the amendment does?
Mr. Chair and members, it clarifies some language relating to the restorative process that's described in the bill. The most significant thing, I think, is on lines 511 to 515. It strikes current law, the language that authorized courts to require children to undergo assessments and then pay the chemical dependency assessment charge of $75. So that's being stricken.
That's right, Mr. Chairman. Again, it's eliminating one of the fees that young people would be charged. That might be an impediment to them actually getting the treatment.
Senator Pappas moves adoption of the A1 amendment as an author's amendment. All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted. Senator Pappas, we have a couple people signed up to testify. We have Jesse Jeppeson from Yellow Medicine County, who I believe is on Zoom. Actually, they're all on Zoom here today. So should we start with Jesse Jeppeson? Is that who's appearing?
That's fine, Mr. Chairman. I was just told she couldn't make it, but maybe she can now.
Is she on? Okay, looks like we have all three signed up here, have shown up online.
Okay,
So,
sounds good.
Ms. Jeppeson, why don't you start us off here?
All right, thank you all very much. I am Jessie Jepson, Yellow Medicine County Restorative Justice. I've been a restorative practitioner for 12 years, and I'm here to share a story of a restitution case we had come through Circle back in 2018. We had 4 juveniles destroy a vehicle they believed to be abandoned out behind a trailer park that we later learned was actually someone's vehicle they used for harvest in the fall. So what had happened is this individual did not have insurance on his vehicle, and all of the juveniles involved were under 12, so none of them obviously able to work. So the This came through Circle. I believe most of you understand what Circle is, but just in case, it's a restorative practice that we use in Yellow Medicine County to bring together the wrongdoer, the juvenile, the person that was harmed by the incident, anyone affected, community members, and then the supports of the participants to come together and come up with the sentence, which is why it's called Circle Sentencing. So we handle the restitution and community service hours and such. So in this situation, the victim was requesting over $3,000 for the vehicle that he didn't have insurance on, and we were trying to figure it out. What we ended up doing was calling him and involving him in the Circle process via phone. He wasn't comfortable attending the Circle at this point because of being very angry with the youth who committed this. And so we came to consensus on paying him back $1,800, which is what the Kelly Blue Book value of the vehicle was, and which he would have gotten from insurance had he had insurance on the vehicle. The two young men who were involved in our Circle chose to start washing the inside of cars, detail vehicles, in order to pay that back. So one of our community members paid the $900, which was their portion, up front so that he could use that to replace his vehicle, and then we began paying her back. So they washed a total of 45 vehicle interiors to then pay this back over the time in Circle sentencing. And when it was all, they also, I should include that they wrote thank you letters to each person, and the majority of the people whose vehicles were cleaned were probation officers, law enforcement, social workers, anyone who worked within the building. And when we were done, along with the victim letters, the apology letters that the youth had sent, when we talked to the victim about coming to Circle and participating and being able to ask questions of these young men and why they had done this to his vehicle, he said that he didn't feel that was necessary. He felt that they had shown that they had repaired what had happened, and that he just asked that we told him he was a kid at 1.2 and had made mistakes. So he was satisfied and didn't feel the need to do that. I think that is I think I clicked all of what I was hoping to, and just sharing how that restitution was taken care of, similar to our volunteer paying it if this funds were available to take care of the restitution.
Thank you, Ms. Jepson. Appreciate your testimony today. We'll also receive testimony from either Sharon Hendricks or Morgan Coons from Hennepin County, I understand.
Thank you, Chair and members. My name is Morgan Coons. I'm the managing attorney of the Youth Prosecution Division at the Hennepin County Attorney's Office. Allowing youth to repay restitution while engaging in restorative programming is a smart way to balance justice for victims with programming for youth. These programs are proven effective in Hennepin County and across the state, and we strongly encourage efforts to increase their use. This bill would also help refocus accountability for youth away from fines and fees and towards more effective interventions like restorative justice. Fines are already uncommon for juvenile offenders, and multiple counties around the state do not use fines. Juvenile offenders, fines just do not help restore victims, they don't reduce recidivism, and they do not provide meaningful accountability for youth. Holding youth accountable to victims, to their family, and to their community are much more effective interventions. Current law already has an array of other options for judges when sentencing juveniles other than fines. These include things like probation supervision, programming, mentoring, anger management, defensive driving courses, chemical dependency or mental health courses, therapy, job training, restorative programs. Judges can order youth to attend school, follow the rules at home, to write a reflection essay, to draft a letter of apology, to complete community service. All of these types of interventions are just much more effective at holding youth accountable. Our data in Hennepin County show that youth who complete diversion programs, including restorative programs, are less likely than their peers to recidivate. This is supported by national data and academic research. This bill moves Minnesota in the right direction. It helps victims by increasing the likelihood they will receive restitution, and it helps juvenile offenders by holding them accountable to their families, to their victims, and to their community. I'm happy to take any questions. Thank you.
Thank you, Mr. Coons. Appreciate your testimony. I'm also told Sharon Hendricks is from Yellow Medicine County. So, Ms. Hendricks, if you are with us, go ahead and if you could give us a short description of what you'd like to testify to as well. We do have one more bill to hear yet today.
All I would add is that what Jesse Jepson described is a form of restorative restitution, and that is what we are hopeful to be able to continue providing across the state and have access to funds that would allow victims reparation while children and families figure things out and work to make things right when they don't have that money up front. Thank you.
Thank you for your testimony. Appreciate it. Anyone else in the room wish to testify in connection with this bill? Any questions or comments from members of the committee?
Mr. Chairman.
Senator Pappas.
I did forget to mention that this would authorize the Office of Restorative Practice to award grants to provide the restitution funds that allow a victim of juvenile offense, juvenile petty offense, or major traffic offense committed by a juvenile to obtain monetary compensation to satisfy the restitution obligations of a child who participates in a restorative program. And they would use the money that was appropriated last year, a portion of that, to help with these restitution grants.
All right, members, it's the intent to lay this bill over for possible inclusion here in the Judiciary Committee. Seeing no further questions or testimony, this bill is laid over. Thank you.
Thank you.
One last bill on today's agenda, Senator Howe, Senate File 4205. Members, in your packet, there are some letters in support of the bill. We don't have any testifiers who have signed up ahead of time. Senator Howe.
Thank you, Mr. Chair, and thank you, committee members. Senate File 4205 basically provides $48 million for grants to counties and fire departments throughout the state to upgrade their radios. If you remember back when 9/11 happened, one of the big outcomes of that was the discussion of interoperability of departments with the ability to talk to one another. So there was a big outpouring. We funded a lot of radios. The problem is those are not being able to be serviced anymore, and we're way behind on replacing them. And if you can imagine, the 700 and 800 megahertz radios, they're not like our old VHF radios that we used to use, which we used for a long period of time. These things are much like your computers, your cell phones. They need to be updated more often. And what we're finding is most of these radios that we had before, that we purchased now, we can't update them anymore. The parts aren't there to fix them. And many of our volunteer and smaller departments and our less populated counties are really struggling to actually outlay the money because they, depending upon the model and what they do, a radio costs between $2,500 and $5,000. So it's, to give you an example what that's like, in 2022, there was a 911 call out in the city of Clinton in Big Stone County. The caller said large elevator was on fire. There were 36 departments that responded to that. And after that, Governor Walz was out there. One of the guys that was there was the assistant commander that shared his concern on how small his department was, and he was unable to replace his aging radios. It was just, they have a small tax base, their members are all volunteers. Stevens County, which is near out there where I grew up, they've actually been funding this. They're still 230 radios short in their county. So, Mr. Chair, we're just, if we did this, and we did this every year, it would still take us 4 years to fully fund this. So, Mr. Chair, that's the bill.
Senator Pappas.
Well, Mr. Chairman, one of my fun activities yesterday, coincidentally, was looking up the revenue bonds on the MMB website. And it turns out, this is so funny that you're here today, is that, we spent $60 million in 2009 on the 911 public safety radio system. We spent another $60 million in 2011. And then in 2016, we spent the $91.7 million we sold revenue bonds for. So I don't know, Senator Howe, if you're familiar with that, but how was that? That was 8 years ago, 2016, and all the system needs to be updated now because it's 8 years old, or there's just, do you know anything about this?
Senator Howe.
Or does
In
anyone
fact, I think
know?
last year, there was probably about $4 million allocated to this, if I remember right. I don't know, I know Senator Seeberger carried a bill for $4 million, I believe, last year. The problem is you only get, a half a dozen years out of these radios, and that is the problem. So we got to continue to go, and the last time I heard, there was like a $230 million need that remains out there. So and that's what we need to do. It's an ongoing issue that continues to go. That's the problem we have. It's with any technology. If you could imagine having how often you replace your computer.
Yeah.
It's because that's what they are. They're,
Right.
I don't have an answer for it. It's the problem of technology of today. And we need to figure out how to continually fund this need because our public safety folks out there need to be able to communicate.
Thank you.
Senator Howe, I would encourage you to work on a long-term funding strategy for solving these technological issues rather than us lurching from occasional year to occasional year with one-time appropriations out of the general fund. I think if you could figure that out, you would do the whole state a good service.
Absolutely.
Any other testifiers in the room wish to participate in this discussion? Anyone on the committee have any questions or comments? All right, members, we have concluded. Senate File 4205 is laid over for possible inclusion. Now, for upcoming, we have a hearing on Wednesday. We are going to have conversations with members of the committee and see, because there is no floor session on Wednesday, whether or not we might be in a position to start earlier than 12:30, since we have a longer agenda and might be able to get done earlier in the day as a result of that. So please, I guess, watch for an email from our staff inquiring about your availability late morning instead of 12:30. And appreciate your work today. We are adjourned.